Date of judgment.
Date of judgment, my lord,
22/7/11.
22/7.
Total period of custody.
About 12 years.
Offense.
Offense 302.
Read with.
मतलब sole appellant, sole accused.
Yes.
Yes. Let us see the new order.
12 साल से ये पति जेल में है। मामला ये होता है कि एक रात पति पत्नी घर में ही रहते हैं। सुबह जो पत्नी हैं वो मृत पाई जाती हैं। इसकी वो सूचना अपने संबंधितों को देते हैं और सर्कमस्टेंशियल एविडेंस के आधार पे उनके ऊपर मामला बनता है। 12 साल से जेल में हैं। तकरीबन 9 साल से उनकी जो बेल एप्लीकेशन है वो घूम रही है। तो ये पूरा मामला है। आइए देखिए।
दिनांक 31/10/2010 को सुबह 8:30 बजे थाना कोलारस जिला शिवपुरी में ग्राम मोहरा की कोटवार फरियादिया महिला भक्तों ने थाने में इस आशय की सूचना दी कि आज सुबह 5 बजे अभियुक्त मंगलिया जाटम ने उसके पास आकर उसे बताया कि मंगलिया की पत्नी विद्या मर गई है। पूछने पर उसने बताया कि उसने किवाड़ खोले तो वह पाटोर के अंदर मरी पड़ी मिली। अभियुक्त मंगलिया के बताने पर कोटवार महिला भक्तों मौके पर पहुंची और उसने देखा कि विद्या मरी पड़ी है। विद्या कैसे मरी इसका पता नहीं है। फिर महिला भक्तों ने यह बात ज्ञानी और कैलाश को बताई। फिर उसने थाना आकर कैलारस आकर पुलिस को सूचना दी, जिस पर पुलिस ने मर्ग क्रमांक 100 अंडर सेक्शन इतना कायम करते हुए जांच प्रारंभ की। नेक्स्ट एडिट में
क्या आया क्या है?
मतलब ये है कि ये इसकी वाइफ की डेथ हुई है। दैट इज होमिसाइडल।
कैसे किसके आधार पर पता है?
मतलब ये उसको कुल 5 इंजरीज हैं। आउट ऑफ देम 4 वर इंसाइज्ड।
इसने इंजरी कॉज करी है, इसका प्रमाण क्या आया?
मतलब सर्कमस्टेंशियल एविडेंस का केस है। ये एविडेंस में आया कि ये ही अकेला दोनों घर पे थे। दूसरे दिन इसने कोटवार को सूचना दी।
ठीक। क्रिमिनल अपील नंबर 625 और 30। First application.
My lord.
This is the first application under 389 CRPC. Filed by appellant. No, this is the first application in CRPC seeking suspension of sentence. Appellant stands convicted for offence so and so and sentence for so and so. Appellant so far has undergone 12 years of sentence as stated by legal counsel of the appellant and not disputed by the government counsel. Stop. As per prosecution story, the deceased, क्या नाम था उसका?
मंगलिया
नहीं डिसीज
विद्याबाई
Vidyabai was allegedly found dead inside the room. नहीं ऐसा करिए, निकाल दीजिए. As per prosecution story, कोटवार of village Mohra, complainant Bhaggo lady, Bhaggo informed police station Kolaras Shivpuri at about 10:20 a.m. on 31st of October 2010 that the appellant accused Mangalia Jato came to her at about 5 in the morning and informed that his wife Vidya has passed away. Now was found dead when he opened the room where she was fast asleep. Stop. She had also informed the said fact to one Gyani and Kailash of the same village on registration of the Marg at number 93/10 under 172 CRPC, the inquiry started. So thereafter, upon collection of the incriminating material on record, the FIR was registered at the crime case number 291 of 10 under 302 read with 449 CRPC. The appellant was taken into custody for investigation. Upon completion of the investigation, challan was filed. Case was committed for the sessions trial. The trial court, upon critical evaluation of the evidence based on record, reached the conclusion. Upon critical evaluation of the evidence based on record, found the case that the instant case being is that of a circumstantial evidence, and since the chain was compared, appellant was found to have been caused homicidal death of the deceased, as according to trial court, sessions court, the chain of circumstance stood completed with the facts brought on record. And accordingly convicted and sentenced as apostate. Shri Padam Singh, advocate with she so and so and she so and so, while criticizing the impugned judgment, inter alia contended that the impugned judgment suffers from perversity of approach and based on surmises and conjectures. The relevant evidence has been ignored and irrational conclusion has been drawn, finding the appellant guilty of the alleged offence. Even otherwise, appellant has suffered jail incarceration since 12 years, for last 12 years. He has no incidents. Appeal is of the 2013 and so far has not seen the light of the day for the matter of for final hearing. Never seen the light of the day, much less for final hearing. So, under such circumstances, it is prayed that sentence may be suspended. Per contra, Shri Rajesh Shukla, Deputy Advocate General, while supporting the impugned judgment, submits that the judgment is based upon proper appreciation of the evidence placed on record. So, no exception thereto can be taken in the matter of suspension of sentence. So, it's a case of homicidal death caused by husband, death of wife caused by husband. Hence, application deserves to be dismissed. Upon hearing counsel for the parties, though this court refrains from commenting upon the rival contentions touching the merits of the case, regard being had to the fact appellant has suffered jail incarceration for the last over 12 years. Appeal is of the 13. Appellant, it's a jail appeal. Appellant has no criminal incidents. He is entitled for suspension sentence. A court is suspended 50,000.